and a warm welcome to the AI with Arun show. How many times have you signed up for a new app, clicked I agree without reading the 50-page privacy policy and instantly felt that pang of digital anxiety? You know your personal information, your photos, your location, your purchasing habits is being collected, but you have no control over it, where it goes, or who sees it. For years, the Indian internet has felt like the Wild West. Well, that era is officially over. In November 2025, India underwent a seismic shift with the official notification of the Digital Personal Data Protection DPDP Rules 2025. These rules are the detailed instructions that turn the core privacy law, the DPDPA 2023, into an enforceable regulatory reality. This is not just bureaucratic paperwork, it's about establishing a robust, citizen centric, and innovation friendly ecosystem for data governance. To understand these rules, we need to go back to the foundation. This whole journey traces its roots to the landmark A.S. Puttaswamy judgment of 2017, where the Supreme Court declared the right to privacy a fundamental right under the Indian Constitution. So, what is the law trying to do? It's performing a delicate balancing act. On one side, we have the protection of your personal autonomy and privacy. On the other side, we have the legitimate need to process data for innovation and a trusted digital economy. The goal is clear: curb the unauthorized commercial exploitation of data and reduce digital harms. Crucially, these rules follow the SARL design principle. SARL stands for simple, accessible, rational, and actionable. Unlike many complex laws globally, Indian governments prioritize plain language and illustrative examples so that the average citizen, not just lawyers, can understand the rules and small businesses can actually implement them. Now, let us learn the new rules in this digital drama. You are no longer just a user or a customer. You are a powerful data principal. So, who is the data principal? It is you. You are the Indian citizen who owns the data and whose privacy is being protected. The rules fundamentally empower you, the data fiduciary, the company. Now, this is the company, the government agency, or the app that processes your data. Notice the name fiduciary. This emphasizes a trust based relationship. They are your trustees, not the owners of your data. And then the third entity, the Data Protection Board of India, the referee. Now, this is the DBI, Data Protection Board of India. The board is the enforcement wing, a digital office designed to handle complaints and dispense justice primarily through online mechanisms. They are setting up their operational machinery now. In the old internet, consent was a handshake in the dark. In the new internet, consent is the bedrock of all data processing. It must be free, specific, informed, unconditional, and unambiguous. We are moving away from bundled consent, where you have to agree to sharing unrelated data just to access a service. Before asking for consent, data fiduciary must give you a notice. This notice cannot be buried in small print. It must be a standalone interface presented in simple language. So let's take an example. The notice must list exactly what personal data is being collected and the exact purpose for processing, which is called the purpose limitation. If an e-commerce app collects your address for delivery, they cannot use that data for personalized marketing unless they ask you separately for consent. This forces transparency and stops data misuse from the start. The consent manager, now this is arguably the most revolutionary part of the Indian framework. Imagine having a single remote control for all your privacy settings across every app and service you use. This is what a consent manager is: a novel institutional innovation. These are third party entities registered with the DPBI. You might open a CM or a consent manager app and see a dashboard showing every company you have ever given data to. From that dashboard, you can revoke consent for a specific company with a single click. The rules mandate that withdrawing consent must be as easy as giving it. If you gave consent with one tap, you should be able to revoke it with one tap. Consent managers must remain data blind. They only manage the digital token of consent, ensuring they never see or store your actual personal data, which remains with the data fiduciary. The government knew that overhauling the digital economy could not happen overnight, so they created a staggered timeline. This gives companies time to prepare. So, phase one is the immediate activation, which is November 2025. The legal foundation was laid immediately. The Data Protection Board, DPBI, was legally constituted. This ensures that the referee is functional and ready before the game of compliance fully starts. Phase 2 is the Consent Manager ecosystem by November 2026. So, 1 year from notification, the rules governing the registration and oversight of those consent managers kick in. This 12-month window reflects the technical complexity of building that secure, interoperable consent layer. And phase 3 is fully operational compliance by May 2027. Now, this is the hard deadline. By May 2027, the bulk of your rights and the company's duties, including breach notification, protocols, mandatory privacy notices, and full penalties, become active. The 18-month countdown is on. As a data principle, the law now gives you the specific powers to manage your data, treating it like property you own. So let's talk about each one of the features. One is right to accuracy. Companies must make reasonable efforts to ensure the accuracy and completeness of your data. Why? Because if they use inaccurate data to make a decision about you, say a credit score or insurance, you have the right to challenge that. Two is right to erasure. Data must be deleted when the purpose for which it was collected is served. This prevents the indefinite hoarding of zombie data that a company no longer needs. If you withdraw consent, the fiduciary is legally obligated to erase the data unless another law requires them to keep it. For example, tax records. 3. Grievance protocol. If you have a complaint, you first file it with the company, the data fiduciary, or consent manager. This is tier 1. Only if they fail to resolve the grievance satisfactorily can you approach the ultimate digital referee, which is DPBI, and that is tier 2. For companies, being a fiduciary means much more than just having a privacy policy. It means taking active responsibility. Companies are mandated to implement reasonable security safeguards to prevent data breaches. This includes robust technical and organizational measures like encryption, access control, and masking of data to stop unauthorized access. Furthermore, the law focuses on accountability through documentation. Data fiduciaries must retain logs documenting the consent they received and the processing they performed for at least 1 year. The rules also incentivize good hygiene. If you, the data principal, have been inactive for a specific period, standard practice often suggests 3 years, the company is encouraged to erase your data. Every company's biggest fear is a data breach. The new rules define a breach as any unauthorized processing, disclosure, or loss of access that compromises the confidentiality, integrity, and availability of your data. In the event of a breach, the fiduciary has a dual notification duty. They must notify both the Data Protection Board, the DPBI, and all affected data principals or the users. The timeline is strict. Notifications must happen promptly or without delay. The industry often interprets this as a very tight window, like 72 hours, depending on the board's guidance. Critically, the notice to you, the user, must be in plain language. It must clearly explain what happened, the impact it has on you, and the steps the company is taking to fix the harm. This requirement forces complete transparency and drives security improvements. The rules take an uncompromising stance when it comes to children, defined as individuals under 18. This is a zero tolerance area. Fiduciaries must obtain verifiable parental consent (VPC) from a parent or guardian before processing any personal data of a child. So, how is verifiable done? The rules leverage India's digital public infrastructure, specifically DigiLocker. A parent can use a token generated by a DigiLocker to prove they are the guardian without sharing their underlying Aadhaar or ID documents with the app itself. And here is the most important prohibition. Companies are strictly prohibited from tracking, behavioral monitoring, or serving targeted advertising to children, period. However, there are smart exceptions or exemptions. Processing for essential services like healthcare and education can be exempted from strict parental consent to ensure that children still have access to vital services. So, why are companies scrambling? Because the fines are enormous and designed to be a powerful financial deterrent. First, we have significant data fiduciaries. Now, these are the giants, the large social media platforms, major health tech companies, and telecom operators, designed or designated based on the volume, sensitivity, and risk of the data that they process. The SDFs, significant data fiduciaries, face much steeper duties. They must appoint a data protection officer, a DPO, based in India and hire an independent data auditor for compliance checks. Now the penalties. The board can impose fines up to rupees 250 crores, approximately 30 million USD, for a single instance of failing to implement reasonable security safeguards. Failure to notify the board or affected users of a data breach can cost up to 200 crore Indian rupees. Breaching the obligations regarding children's data can also reach up to rupees 200 crores. So as you can see, the cost of failure is astronomical. The DPDP rules 2025 signify the definitive end of the Wild West era of the Indian internet. The central theme is the empowerment of the Indian citizen. The ability to withdraw consent easily, aided by consent managers, forces companies to treat your data as a borrowed asset, not as their own property. India is charting its own course, aiming for an Indian way to privacy that is distinct from the rigid, highly prescriptive frameworks seen elsewhere. The framework is fundamentally betting on technology, using consent managers and a digital office, the DPBI, to solve complex problems created by technology, making the system scalable and accessible. The countdown to full compliance is May 2027 has begun. For all digital users and businesses, the message is simple: your data, your rules. This is the new digital reality. Now, think of it this way. Now, this is an analogy. The DPDP rules are like installing a smart security system on your personal data home. Before, companies could sneak in through fine print hidden in the bushes. Now they must ring a visible doorbell, the notice, state their exact purpose, and ask for a specific temporal key, which is a granular consent. If they violate that trust, a massive digitally connected alarm goes off immediately, which is your DPBI, triggering an enormous financial penalty, ensuring they treat your data like priceless jewels, not free for all public property. With that, we come to the end of the show. Please support our work by joining us as a member. All you have to do is go to the description of this video, and at the very bottom, you will see the link to becoming a member. And if you learned anything in this video, please like, share, and subscribe to the AI with Arun show. Thank you for watching. We'll be back soon.